All right, good evening everyone, and a very warm welcome to the Centre for English Legal History's final Easter term seminar for this year. As always, a couple of brief notifications, a reminder to everyone that this seminar is being recorded by Microsoft Teams and will be uploaded to the Centre's YouTube channel. And secondly, as usual, we are planning to head to the Granta pub afterwards for drinks and or dinner. Dr. Eldridge has very kindly agreed to join us, and you're all very welcome to come along. So this evening, it's a pleasure to have Dr. Lorren Eldridge presenting to us. Dr. Eldridge is currently an early career fellow in legal history at the University of Edinburgh. She is also convener of the Alan Watson Seminar for Legal History at Edinburgh Law School, co-convener of the Law School's Forum for Historical Jurisprudence, and a member of the editorial board for the journal Comparative Legal History. Oh, that's just changed. Oh dear, that's just changed.
I've just left the journal Comparative Legal History. I'm with the conveyancer now. It's very exciting.
Dr. Eldridge obtained her undergraduate degree and PhD at the University of Oxford, has held teaching positions at the University of Oxford and the University of Dundee. Her forthcoming book, Law and the Medieval Village Community, Reinvigorating Historical Jurisprudence, will be released next month. Today she will be presenting on medieval leases and modern leases in English law. Please join me in welcoming Dr. Eldridge.
Thank you. So I'm hoping that everyone online can hear at the moment as well. And if I'm not standing close enough to the microphone, then you'll just have to wave vigorously because I can't see the chat. So this paper for this evening is based partly on work that I'm doing for a project which meets in Oslo next month, and partly on what has become a much bigger and longer term project on the history of leases. So the Oslo project is about medieval law and modernity after 1850, and it aims to think about medieval ideas and texts and how they get picked up and used in more recent law. And in particular, they're trying in that project to engage lots of different jurisdictions and to draw a contrast between codified and non-codified legal systems, with the assumption, or at least the starting premise, that uncodified systems like English law will have a more direct relationship with their own historical past, or are likely to. So I began thinking about one of our most code-like projects as English lawyers, and that's the Law of Property Act 1925, and that engages with some of our most medieval law. And the Law of Property Act 1925 remains one of our core statutes that we use now governing land rights in England and Wales, alongside the more recent Land Registration Act 2002. And the history of the 1925 Act is significant for a number of reasons, not least the fact that modern lawyers find it throws up problems constantly in litigation. So I've been trying recently to untangle the fairly complicated and intimidating swathes of documentation relating to the development of that Act, and then how that relates to the medieval law on which English land law is so notoriously supposed to rely. And I want to try and say something sensible about the perception of medieval law at the time of this codification-like event. And of course, it's not a code, it's not comprehensive, it wasn't intended to be, but it's about as code-like as we get in English law. And I want to think about the extent to which substantive legal changes in doctrine were and were not introduced in 1925. Because at least superficially, that legislation made changes which made English land law more rational, more abstract, and more suited to the needs of a modern market in land. And the full impact of those changes took quite a long time to be felt, not least because of the Second World War. Perhaps we're still figuring them out now. As I said, we're still getting a lot of litigation which engages the 1925 Act. And part of a historical investigation of this legislation, I think, must be about helping to clarify what it did, why, and how well it achieved those aims in hindsight. So obviously that's still a huge question. And at this stage, I have lots of questions I haven't answered. This is ballooned from what was meant to be a paper into a full-on book project with a Leverhulme grant. But for today's purposes, what I want to talk about is some of the things I think I can say so far. And I focused on leases for this project because I think they're a very good way into understanding what the Law of Property Act 1925 was trying to achieve and how it engaged with the law as it had hitherto been. And I'll explain more about that in a moment. But I do want to caveat quickly that at least for today, Perhaps not so much for the book itself, that might change, but right now I'm not trying to say anything new about medieval law itself. There's already lots of good literature explaining how the distinction between freehold and leasehold first developed, the contractual and/or chattel nature of early leases for a term of years, how that changed over time in respect to the actions available to lessees, and some of that literature is written by people in this room. So what I'm trying to do here is build on that understanding and think about how 1925 was intended to be a conscious break with the past, and indeed how well understood that past actually was by those key legislative drafters and actors. And if we were in a legal system which was generally more inclined towards codification, we would probably be able to say something like it was codified in the period 1922 to 1925. The case law and legislation that comes before has little to no bearing on it going forward. But of course, that's not how English law works. I'm going to run through the basic ideas, the medieval ideas, fairly swiftly to make sure that we're all on the same page. But I realise that for many in this audience, that will be a bit trite. So we're going to do just 5 minutes on the most pertinent bits of medieval land law. So as every modern undergraduate hopefully knows, English land law is premised not on any more absolute concept of ownership in land, like a Roman concept of dominium, but on estates. And an estate can be conceptualized as an abstract interposed between the person and the thing, such that the person's rights are in the estate and not the thing, the land itself. Estates are defined by reference to periods of time, and again, we can contrast that with the Roman law approach. And the type of estate in land you have tells you how long in duration the rights are. Milsom said that this idea of estates and what Burkes would famously call slices of time was made necessary by the idea of tenure. So what then is tenure? So tenure is a more complex legal and social relationship whereby a tenant held land of a lord. That had fairly complex doctrinal rules of its own, which developed particularly in the 13th and 14th centuries. A tenure was something like what we might call a hereditary contract for the profits of capital, i.e. the land, and that therefore involves a mix of personal and real rights. So you have duties and services owed to the other person, and both parties also have a relationship with the land itself. And if we think about how leases fit into this, they don't fit well. So they could be temporary, short and more commercial, or they could be longer and more enduring personal relationships of the sort envisioned by the word tenure. But the idea of ownership divided in time in the form of estates developed long beyond the realities from the medieval period and the survival of medieval tenure itself. And this terminology is quite important for my purposes because I think the distinctions between these terms, estates and tenure, get a bit lost around the 1925 reforms and in the modern law, which I'll come back to in a moment. You will have noticed, though, that on the slide here, I deliberately chose some more recent descriptions for the quotes. John Baker, in his introduction, summarises how some interests like leases grew outside that medieval tenurial scheme of real property, where real property involved the idea of season, the protection of praecipi actions, and the vindication of rights with a remedy in rem, so the recovery of the thing itself as opposed to damages. And leases were characterised differently as chattels, so personal property, but quite quickly developed features resembling those of freehold estates. Originally, in a lease or a term of years relationship, you have no lord-man relationship, no homage, no warranty, and those things were all really important for freeholds. And the 12th century treatise Glanville says that leases are contracts, and that seems like a fairly accurate description for that period. But we fairly swiftly see the development of these legal remedies, which treat lessees as more than parties to a contract, and as having real property-like rights, if not real property rights themselves. And this comes to look a lot like the holder of a freehold estate in fee simple by the time we get to 1925. Just drawing on a couple of other concepts from the medieval law before we focus on 1925, we can also think about the actions available to lessees over time. So by the late 13th century, there's a writ of covenant, which makes a lease what we might call in modern terms a specifically enforceable contract. This fell out of use fairly quickly in the 14th century as covenant moved in a different direction. But the action of ejectment also developed to protect leaseholders to enable them to get possession of the land back. And this led Milsom to say that leases started as contracts, but grew into what he described as a counterfeit proprietary interest, because protection as contracts was deemed socially or economically insufficient. And the turning point we usually pick up on for this is the case of Gurns and Smythe, or Gurns and Smith, in 1499, which is taken as our turning point for a leasehold becoming an estate in land. This has been the subject of some debate. Simpson said that by the 16th century they were tenurial but not estates because, for instance, you couldn't entail them. Couldn't do that till 1925. John Baker says that they became estates in land by virtue of an act of judicial legislation in Gurns. And Milsom focused on the statute of uses as a statutory way of enabling this to happen as opposed to the case law itself. Nowadays, we don't need to argue about it because we have Section 1 of the LPA 1925, which tells us that leases for a term of years are most certainly an estate in land. But I think it's really interesting, and the core of the project in some ways, is wondering whether they thought that was a change or not. One other key aspect of the medieval law was the distinction, which I'm not going to get into today, but the distinction that lasted until quite recently between leases for a term of years and leases for lives. A lease for a longer period of time, which did involve property rights, was a freehold estate in land, lease for lives, and a lease for years was usually considered, or at least often considered, a more commercial arrangement. And this distinction was formally maintained right until the 1925 Act and its predecessors, so that became a really important difference between different kinds of leases as well. Their remedies, though, converged. So whilst remedies developed which protected leases for a term of years in much the same way as if they were rights in land, they also continued to exhibit some features of personal property. And one of the main features there was they were both heritable and divisible property, whereas freehold estates in land could not be straightforwardly devised by will until the Statute of Wills in 1540, and even then it was only a third of the land. So that's a very whistle-stop tour of the key medieval points, and for the purposes of this paper, I don't really want to pick up too much on the medieval law. I want to think about how it was interpreted and used in 1925. The other thing that I'm going to just blatantly skip over is the entire 16th century. I think, and this is something I'm going to pick up later in the actual book, but developments in the 16th century created, I think, very strong incentives for leases to stay as they were and not converge any further with freehold property in land. And this is what Milsom, I think, was focusing on when he talks about the statute of uses. So the statute of enrolments in 1536 talked about estates of inheritance or freehold, and the fact it didn't include term of years enabled a particular style of conveyancing. That technique could only be omitted after 1841, so it's really only with this period of Victorian reform that it becomes possible to start thinking about leases differently. And again, without getting into too much detail today, if you had done it any earlier, you would have messed up the entire basis of freehold conveyancing, which presumably nobody wanted. So that's the whistle-stop tour of the background. As I said just now, since 1926, 1st of January 1926, when the 1925 Act came into force, Section 1 on the slide here of the Law of Property Act 1925 tells us there are two and only two estates in land in English law. They are the freehold estate in fee simple and the leasehold estate for a term of years absolute. And as I will explain more fully in a moment, the lease for a term of years, what we conventionally refer to as just a lease today, they were supposed to be largely unchanged by the 1925 Act. The focus was very much on freehold estates, on those things like leases for lives that I was talking about just now. But the case law since, right up until there was a Supreme Court case on this in March, is littered with cases where we're really worried about the nature of leases. And they've proved quite conceptually challenging, particularly in the 20th century. The topic of potential statutory reform is also hugely important at the moment. We have lots of conversations going on about residential housing, blocks of flats, common hold reform, and now also the Law Commission has just announced that it's going to look into commercial landlord and tenant law. So the starting point from all this is using this medieval knowledge that I've just summarised, knowing something about the history of leases, knowing that the modern law is a bit messy and incoherent. It would be quite good to figure out how we got into this position as a part of any reform process. So if I'm teaching contemporary English land law to undergraduates, I will probably start with Section 1 fairly early on in the course. But we don't, as teachers of modern law, tend to get into much further depth on what the word estate means there. We'll explain to students that property in land is treated differently to personal property. We will talk about the idea of an estate. We'll tell them it has medieval origins. We might tell them that an estate is about the duration of your rights to use and possess the land. We might mention there used to be other estates in land. But we're almost certainly not going to explain to them on the core undergraduate course what an entail is, although with Downton Abbey that might be easier than it once was. We'll then tell them the freehold estate, or the fee simple absolute in possession, as it's worded in the statute, is the closest thing to ownership of land that English law has. But then we're going to move on in a modern law course fairly swiftly. We're probably going to move on to explaining something like registration, or the difference between legal and equitable rights in land. Technicalities will undoubtedly arise later in the course with the 1925 Act, because we're going to have to try and explain severance of joint tenancies, or hard cases relating to the modern law of leases. But students are likely to take from that now, and these students then become lawyers, some of them at least, they're going to take that freehold is something like owning and leasehold is something like possessing for either a short or a long time. They're unlikely to appreciate that an estate tells you about duration, not the content of rights, and that it corresponds to fee simple and term of years, whilst freehold and leasehold tell you about tenure. It also hasn't been part of my undergraduate teaching routine, and probably isn't most people's, to tell undergraduates what the Law of Property Act 1925 was supposed to be for. And the goal of that act was supposedly to effect the assimilation of real property to personal property insofar as that was possible. If I did tell them that, their eyes would probably glaze over. And that might be okay as far as the constraints of an undergraduate syllabus go, but it does beg the question, do English lawyers in general, post-1925, need to know any more about things like the doctrine of estates and the concept of tenure in order to get the law right and to do their jobs properly? And obviously it'd be a bit weird to come to a legal history seminar and say the answer is no to that question. And I think a lot of the hard cases in leases in particular would benefit from a bit more of an understanding of the history of leases. And I've talked about that a bit in my recent LQR article about some of the hard cases. And it's not just me. So it's perhaps less popular now to describe English land law as still in essence feudal or as unchanged in substance by the 1925 Acts. But certainly it was normal to make that claim well into the 20th century, and you saw some quotes on the previous slide illustrating that. And clearly we're still using some of the old terminology as well. We still talk about estates in land, if nothing else. So as soon as you start to delve a bit deeper into the history of the 1925 Act, you realise you've made a terrible mistake. The 1925 Acts, of which there were originally 6, were the culmination of decades of previous statutory reforms, proposals, commissions, arguments, and of course political currents. Commissions and committees with the role of considering the law of property in general were a feature of the legal landscape from about 1830 onwards, and they continue obviously to be a key feature of the landscape in relation to land law today. That first commission in 1830 recommended several changes to conveyancing practice, which did result in a number of statutes in the late 19th century. So we had the Real Property Act 1845, which enacted that corporeal hereditaments would lie in grant, which means basically you can use a deed to transfer land, which makes everything much easier and simpler and faster and cheaper, very importantly. Previously, as I mentioned briefly before, you had to use this lease mechanism, which was invented in the 16th century and made everything, again, slower, more expensive and more technically complicated. So the Vendor and Purchaser Act 1874 also made everything cheaper and simpler. Again, the documents are getting shorter and shorter. The Conveyancing Acts 1881 and 1882 really focused on this because lawyers were paid by the length of the document. So the cheaper the document gets, the better for the client, the worse off the lawyers are, and the smaller all the paperwork gets. And the Settled Land Acts as well, 1881, 1882, promoted the alienation of land and further made reforms to try and make that process as cheap as possible. So there's this clear 19th century trend to focus on process and streamlining process, but not to touch the substance of real property law directly. Then comes the LPA 1922. This was the largest bill that had ever been put before Parliament at the time. Pretty sure it's been superseded by Brexit bills since then. And they immediately followed its passing by revoking almost all of it and restructuring it into 6 separate acts. And if that's not fun enough on its own, they also introduced the Law of Property Amendment Act 1924, which snuck in to tidy up in between, used parliamentary procedures which were designed for non-substantive changes, and of course, obviously, made substantive changes. So in the enthusiastic pursuit of this very snappy goal to assimilate the law of real property to the law of personal property, I think the legislators of the 1920s somewhat inadvertently changed the meaning of some of the key concepts they were using. So a textbook from 1929 tells us there's been a tendency recently to assimilate the branches of the law of immovables rather than do away with the difference between movable and immovable. So the latter, actually doing away with things, would involve things like abolishing tenure, abolishing copyhold, getting rid of the interessi termini. Instead, there was an increase of the use of the classification of real and personal, rather than that more traditional focus, perhaps, on movable versus immovable. And the perception this led to, this kind of gradual change that didn't really touch the hard stuff in the middle, but just sort of tinkered around the edges, this led to a perception among lawyers, particularly the early 20th century lawyers, that the law of real property was in a chaotic state. And that's in some ways surprising, because as I've just said, there were lots of legislative changes throughout the 19th century. But even nearly 100 years of statutory reforms had not been sufficient to update the law for the contemporary market. So this led to a tendency to apologise to the state of English property, presumably to a European audience. And this was picked up particularly nicely in the Hamlin Lectures for 1951, which were given by the Professor of Comparative Law at Oxford, Frederick Lawson. And one of the things that he highlighted and comes through again and again in the parliamentary debates and the Hansard and all the sort of Solicitor's Journal material around this is that real property law seemed to have evolved to meet the needs of a nobility, which is not surprising. We talk about the medieval heritage of English land law. But in an age of commerce, empire, and globalization, a structure of land law which used a variety of instruments to actively prevent land from circulating freely in a market came to seem really, really suspect. And conveyancers knew that many of the transactions they routinely did required quite roundabout mechanism to achieve the goals desired, and to avoid rules which had survived from different social and economic contexts. And Alfred Topham, a Chancery barrister, a member of the committee that was responsible for the 1925 legislation, said in his lectures to barristers and solicitors that the cost of complications arising in even a minority of conveyancing was giving the profession a bad public image and in turn discouraging the market. So there's this very Victorian commercial drive behind these reforms. There's also a wider theoretical context. The 19th century was the age in which analytical jurists began to rise to prominence in English legal thinking. So some of the very important analytical jurists had Roman law training in European institutions, Austin and Holland, for instance, and they were familiar with the apparently more simple approach to property in civil law jurisdictions. So there's this real emphasis that comes out from the theoretical background that simplicity is key, because limited forms of ownership, divided in time or otherwise, are impediments to the free alienation of land. So you have commercial pressures and theoretical pressures both acting on these reforms. There's also a Scottish Enlightenment role here as well, because the tone of Scottish Enlightenment thinking had been that modern government ought to provide a legal system which facilitates national development and scientific or rational law reform. And J. Stuart Anderson has argued that Jeremy Bentham was a big person behind encouraging codification projects in this period, particularly sort of mid-19th century. But Bentham advocated codification from first principles, not the incremental change the lawyers preferred. And again, arguably, you don't get that kind of systematic codification until the 2002 Act. Systematic registration of deeds was also promoted from various corners, and that seemed more in line with the goal of having a rational and systematic approach without sort of, again, touching the core of the doctrine. And some even went to a sort of fairly extreme position and said it was an abdication of governmental responsibility to not institute land registration. And again, they got their own way eventually in 2002. Unfortunately, I doubt any of them were still alive then. Avner Offer's book on the LPA, one of the two books that exist on the history of the statute, says that eventually what we end up with in 1925 is an approach conceived as an alternative to schemes of land registration, on the basis that if you make ordinary conveyancing and the ordinary land law work more smoothly, you won't need registration. In fact, it ends up inevitably being much more complicated than that. As I've said, there were lots of different forces at play, lots of different views coming into this. And the eventual stated position in the 1925 Acts is that if we can commodify real property, we can use that as a precursor for registration. It will pave the way for it. And again, it did eventually, just I don't think they thought there was going to be a 100-year gap. These debates and the method of change notwithstanding, what they were actually proposing to do substantively was also a tricky issue. The adoption of a Roman concept of dominium was not going to happen. So the law concerning personal property became the model instead. It was liable to far fewer criticisms, it was simpler, it was unburdened by medieval doctrine, it seemed much more commercial. It had benefited from an influx of Roman law and the commerce-focused reforming work of Lord Mansfield in the 18th century. Real property had stubbornly resisted any attempt that Mansfield made to mess around with it. The analytical jurists, the theoretical perspective, they were less critical of personal property than real property law, although once again they pointed to the continent and said Roman law is simpler. So it wasn't long before the existence of a differing set of rules for real and personal property became a really hot topic. And the arguments became the differences had for the most part become unjustifiable. I mean, again, if we think back to what I was saying, just 20 minutes ago about the medieval context, that is a huge shift that's happened over, I mean, it has happened over several hundred years, but it's a huge shift of perspective. So the idea becomes, from the 19th century, mid-19th century onwards, to make land as commodity-like as shares in railways or ships. So the plan is simplify, abolish copyhold, abolish tenure, abolish season, get rid of equitable rules about conversions, get rid of heirs, or at least simplify the rules about heirs, and similarly simplify rules about next of kin, make the law simpler on death generally. And with personal property, and for these purposes that included leases because they had developed outside of that medieval tenurial system, derivative interests could be subordinate contracts or trusts, but that meant that chattels, personal property, had these nice, easy to sell legal titles unburdened by the complications associated with real property. At one point, it was even proposed that all land ought to be held on million-year leases, which is much the same as a fee simple practically, but had the advantage of abolishing all of those things without actually having to pass a bill which said so. And section 1, which we had on the previous slide, shows the outcome of that endeavour. It's definitely much simpler. And one of the things which hopefully would have been so obvious that it went without saying to a competent pre-1926 lawyer or conveyancer was that an estate, as I've said already, is a time in the land. If I ask what estate you have, I'm asking what quantum of time your interest in the land will exist for. So the fee simple is potentially, but not necessarily, an indefinite interest in the land. A term of years is, by definition, a time-limited interest. Before 1926, we know we had other legal estates. Fee simple could be conditional as well as absolute. You could have a freehold lease for life, which was also time-limited, but by reference to the life of a person rather than a period of years. Much of that is swept away in 1925. Traditionally, as I've already said, you needed both of those concepts. You needed estate and tenure. They were distinct concepts, and you needed both pieces of information. I should say the exclamation mark on the slide is entirely for Ian Williams, and he couldn't make it even online this evening, so I'm going to have to send him the YouTube link. So to put it differently, estates tell you about successive interests in land, whilst tenure is, or was at least, about simultaneous interests. Tenure tells you about the substance of the relationship between the holder of the rights in the land and the person they hold from. Henry Challis was already complaining in 1911 that tenure was in a decayed state of general application and importance, with the word tenure being wrongly used to refer to the quantum of the estate or interest, not the tenure properly so called. Tenure ought to indicate a particular feudal relation and not a quantum of interest. And it was true that common law tenures were generally associated by that point with particular estates and with freedom as opposed to unfreedom, hence freehold as opposed to copyhold. But that didn't change the meaning of the term tenure itself for Challis. Now, the word tenure doesn't appear in section 1 of the LPA 1925, as we've already seen. It appears 3 times in the whole of that act, once in respect of the abolition of copyhold, once to confirm the word land means land of any tenure, which would seem to indicate that tenure still exists, and once in the context of confirming non-interference with Crown property rights. And nowadays, freehold estates in fee simple are really straightforward in respect of tenure because we don't have knight service or sergeanty or ladders of intermediate feudal lords. A freeholder now technically holds their land in soccage tenure without any extra services or duties attached, and the lord is nominally the king or queen. So tenure is not particularly meaningful in respect of freeholds most of the time, and freeholds are a lot closer to absolute ownership than they once were. But that's not so true for leases, and that's fairly obvious from the language we use. We still call the people in a lease relationship landlord and tenant. We talk about leaseholders having security of tenure, and certain politicians keep insisting that leasehold is feudal and must be abolished, although the latest developments indicate they might be getting over that particular soundbite. A few people did object in the 1920s that it was a bit odd to take the non-tenurial concept of a lease, to call it an estate in land, to not clarify whether it was still personal property or not, still a chattel real or not, and then carry on with the important business of making freehold estates in fee simple as much like the ownership of stocks and shares as possible. One commentator in the House of Lords, I think, called it a fool's paradise, which I quite like because it implies that land law is in some way a paradise. The differences in substance have definitely diminished over time, and the distinction originally turned, as I mentioned briefly earlier, on whether you had an action to recover the land itself or not. So by the start of the 20th century, we can confidently say there are fewer differences between freehold and leasehold than there once were, and those differences are less sweeping and more technical. For instance, a difference of treatment on intestacy. And these residual differences were again significantly reduced by the 1925 Acts. But in all the fuss and argument around the introduction, particularly of the curtain principle, the changes to trusts that were made in 1925, and the impact on family settlements, the changes to the law of inheritance, and the debates raging around the idea of registration of title, leases don't seem to have been anyone's top priority. And it's somewhat bizarre that, in the words of Milsom again, the only tenure which survives in England today did not begin as a tenure at all. In 1889, it had been possible to debate whether references in rights in land, to rights in land, in the most recent Conveyancing Acts, particularly Section 2.2 of the Conveyancing Act 1881, did include a lease for a term of years. So as recently as 1889, it's arguable that they are not rights in land. I've mentioned Chalice already. There's a big argument between Chalice and an anonymous person who's writing in the LQR. I think it might be Henry Hood, but I'm not entirely sure. Because the phrase land of any tenure must necessarily have been by reference to tenures. This is the language used in the statute. And they said leasehold was not and never had been. This is kind of the hill that Chalice decides he's going to die on. And it seemed that to impliedly include all estates and interests in land, whether they were historically tenurial or not, so to include leases for a term of years, would defeat the purpose of having a definition clause in the statute entirely. Chalice goes on to write another article in 1890 and further considers whether a term of years is a tenement, which is a slightly different technical term by reference to the statute de donis, 1285. That definition made reference to entails, and again, I've already mentioned entails. Leases could not be entailed in the way that freeholds could. So it followed again for Chalice, leases aren't tenements. And Chalice did recognise the nature of the lease had changed over time, and that over the course of the late medieval and early modern period, lessees had become more secure in their remedies. In most cases, the termer of a term of years has a kind of security of title. They can bring writs of waste, for instance, from the late 13th century onwards. But for Chalice, this didn't change the fact the term of years was a contract at common law and not an estate. So going back to the Statute of Gloucester, 1278, the remedies there prevented breach of contractual obligations but did not confer property rights, he emphasised. And Chalice remained committed to that view despite the fact that terminology like leasehold tenure was in use and had been in use since Cook on Littleton. And he just said, Chalice said, well, this is just careless language. It's not my fault that Cook didn't know what he was talking about. And that doesn't make a leaseholder tenement or give leaseholders season. And his kind of final parting shot is that the term of years may have pushed itself into the rank of legal estates under Henry VIII. And again, we've already mentioned that briefly. So I think the important thing to take away from this argument that happens in the late 19th century is that as recently as that, there was a real argument that leases weren't tenurial, maybe even weren't estates in land. It wasn't nonsense to talk that way. So it's surprising then that given that debate had been quite recent, given that Henry Chalice was still very active at the time these statutes were enacted in the 1920s, that the reformers don't seem to have thought about addressing the issue and they don't seem to have really engaged with it. The evidence from all the parliamentary papers, the select committee reports and all the literature that I've looked at so far, and I haven't managed to get through all of it yet because there's a lot, suggests this isn't an issue which even necessarily crossed their minds when they were thinking about drafting the statutes. And the key person whose mind I'm interested in relation to this is Sir Leslie Scott Casey, who was the head of the Reform Committee, the leading force behind the bill which would become the 1925 Act. And the one thing you need to know about Leslie Scott was he did not like legal history. He really wasn't keen on real property law. He wasn't a real property lawyer. I think he was a maritime bar barrister. But he really didn't like the Statute of Uses. He had a real sort of personal problem with it for whatever reason. And he really emphasised the value of having just freehold and leasehold as the legal estates in land. But whilst, as we've established already, tenure is not discussed in the text of the statute, when Scott was explaining it to Parliament, he said they also represented two systems of tenure. So that happens in the parliamentary debates, but somehow never actually makes it into the statute. And that's the only discussion of it that I can find so far. So I think my argument here is that, like the system of estates, tenure is simplified by the 1925 Act, but not abolished. It no longer means a contrast between different types of feudal tenure, or medieval tenure, since feudal is a bit of a dodgy term, but between what's left of medieval freehold tenure and the much younger non-medieval leasehold tenure. And I think that's still true today, now, hence the slide. But again, we don't tend to think in those terms anymore. So one result from that is, even more so than when Chalice said it in 1911, it's now incredibly easy to mix up estate and tenure, even in statutory drafting. So if I use the term freehold, I don't tend to tell people that it's in fee simple or in socage tenure, even though technically all I've told you is that this is land which is not held in a state of unfreedom, which hopefully you knew already. There's really only one core set of options for freeholds after 1925. Similarly, if I say leasehold, you'll probably assume I mean an estate in land involving a tenurial relationship of landlord and tenant. And I think it's arguable that the 1925 Act did go more towards abolishing the doctrine of estates in land than modifying it, as claimed by the drafters at the time. But perhaps more importantly for my purposes, the concept of a tenurial relationship is much more important to modern land law than Section 1 would indicate. For instance, the treatment of rent and covenants in leases depend on the tenure, the type of tenancy. And the fact of tenure also traditionally gave rise to other rights and obligations called incidents. Some of those incidents arose from the personal relationship between lord and tenant, like homage, fealty, and aids. Others related to the heritability of the land, like relief, wardship, marriage, and escheat. The incidents didn't attach to the land as such in the way a modern covenant might, but were part of this kind of semi-personal, semi-real landlord-tenant tenurial relationship. And the reformers in 1925 wanted to get rid of all of this baggage and largely succeeded. But tenure does still matter, and in some cases more than others. McGarry and Wade, for instance, has the paragraph you see on the slide there. So they say, for practical purposes, ownership in fee simple, having a freehold, broadly speaking, looks like ownership these days. But because we've suppressed one by one the practical consequences of tenure rather than striking at the root of the theory of tenure itself, it has this nasty habit of popping up. And as I said at the beginning, we know that it's still true that there's no absolute ownership of land in private hands in English law. We still tell our students that routinely. But this really matters for freehold estates in fee simple. It just happens in odd cases. So in the fairly famous case of Penistone Holdings and Rock Ferry from 2021, Lord Justice Lewison, who's very, very good at history, noted that a sheet is one of the last relics of feudal law. And that's the idea that land reverts to the crown if there's no other person holding it. And that obviously is based on the proposition that all land in England is ultimately held of the crown, i.e. all of it is tenurial. There is no such thing as land without an owner. And Penistone referred to the slightly older case of Smuller properties, and I might be mispronouncing that. And I love the quote from the judge that I've put on the slide there, because he said he was initially amused but ultimately dismayed to find that he was having to engage with all of this legal history. And I think it's worth pointing out, and the reason that I brought modern cases to a legal history seminar, that this Smuller case concerned the right of first refusal given to tenants under Part 1 of the Landlord and Tenant Act 1987, which concerned when a private landlord disposes of let premises. In that situation, the freehold had been disclaimed, so it no longer existed. It had evaporated into thin air. And it followed that the land subject to the freehold escheated to the Crown under Section 178 of the Insolvency Act 1986. So none of this is even vaguely medieval law. It's all modern statutes using medieval concepts. It was argued in the case that escheat had been abolished in respect of registered land in 1925 by one of those sibling statutes I mentioned, the Land Registration Act, because of a difference of wording when it was compared to its predecessor act from 1875. But the judge rejected that argument. The draftsmen in 1925 abolished what they explicitly said they'd abolished, which was escheat for treason. but it was never generally abolished, and nor was tenure. So in these unusual and fun cases, it can and must still apply. Now, all of that obviously is absolutely fascinating in itself, but it's not only interesting as a matter of history or rare and niche cases. Because I think the lawyers of the 20th century forgot these medieval concepts very willingly, with something of a good riddance attitude. And this is especially true if you look at the judgments of Lord Denning. In respect of leases, it was easier to forget those pre-1925 rules because for much of the 20th century, the tenurial aspect of leases was regulated quite closely by other statutes. Modern residential rent control started in 1915, prompted by World War I. Land values had changed because of the war. Lots of houses were on long leases fixed at pre-war rents. They'd be much more valuable to the landlords if they could evict the tenants. So we have that. We have rent controls, which start in 1925, preventing the increase of rents as well as preventing evictions. Those controls are extended over time. By the time we get to the mid-20th century, they cover 98% of residential houses. Intervention in private contract business leases starts in 1927. And whilst most long leases, that is leases for 21 years or more, they were outside the original Rent Acts, by the time we get to 1954, the Landlord and Tenant Act, that starts interfering with those as well. And this Landlord and Tenant Act 1954 is the statute which the Law Commission is just about to start their project on and will potentially propose reforming. Also, I haven't had a chance to read the Renters Reform Bill yet because it just came out a few days ago, but as far as I can tell, that seems to reintroduce a number of the controls that existed in the 20th century. Because since 1989, the Rent Acts have been phased out. So now, again, as every undergraduate knows, a proprietary lease and a contractual license are distinguished primarily by their impact on third parties and not things like controls on rent and evictions. That might change again, given the new Renters Reform Bill, but since I haven't read it yet, we're going to just ignore that. For now, the lease license differentiation is really important in leading case law. So much so that in the Manchester and Dutton case quoted there at the bottom of the slide, Lord Justice Laws felt the distinction between leases and licenses was, at least in respect of possessory remedies, the mere rattling of medieval chains without significance, which I find incredibly hard to comprehend. And it's proved a somewhat controversial decision. I think lots of people were upset that it was never fully appealed because it was settled. So we also now have another Law Commission proposal from 2006 that residential leases should be treated as closely regulated consumer contracts. And indeed, that's how licenses tend to be treated now. They tend to be regulated, not just left as freedom of contract. The UK Supreme Court case I mentioned in February, Rakusin and Jepson, was a case which would have absolutely been about privity of estates if it had been leases, but because it was licenses, it fell under this newer statutory regulation. And that focus on protecting the places people live in as their home seems entirely reasonable. And in fact, I think another thing that went without saying in 1925 was that short leases were always intended to be treated more like contracts than long leases. But at that time, that probably wouldn't have engaged ideas about consumer protection. So this is the area where the modern existential crisis for leases emerges, and why I think it's so important to understand what kind of interest we're dealing with. Because we talk now about leases not as tenurial or estates, but as combining contract and proprietary interests. And Bruton is the obvious case, especially combined with Proctor, and I've talked about this in the LQR article that I had out recently. We have one case which talks about leases as contracts without estates in land, another case which says leases can be estates in land with no contractual content whatsoever. Elsewhere, Sue Bright has said that the ideas of property and estates play only residual roles in the law of leases, and that there's been an ideological shift from seeing them as a grant of property to consumer contracts, even dealing with long residential leases. But again, coming back to one of the first slides, Section 1 of the LPA does not talk about leases as estates in land and contracts. And it would be incredibly confusing if they'd done that, because privity of estate and privity of contract engage different principles. Until Lord Denning started to say otherwise in the Artillery Mansions case in 1947, it would have been uncontroversial, I think, to say that the tenant under a lease doesn't owe the landlord rent because of a contract or a promise, although they may have made that as well. But the rent is owed because it's part of the property right, which we call a lease, and that is also annexed to the property right in the landlord's reversion. And that's why leasehold covenants are so useful and why we can and do use them to regulate complex networks of property-related obligations in buildings like tower blocks. If leases were just contracts, they'd be far less useful, and perhaps the Common Hold and Leasehold Reform Act from 2002 would have been more successful in offering an alternative. So what we're really talking about in these modern cases and these modern problems is, I think, the tenurial aspect of leases, the content of the right, as distinct from its duration as an estate. That leases are estates in land, partly because the statute says so, ought to be relatively uncontroversial when we think of it that way. And the fact that a concept is medieval is not in itself a disqualifying feature for usefulness, even if there are many Lord Denning case reports to the contrary. Tenure is and always has been a complex mix of what we now call personal and real rights. Some aspects can be conceptualized as contractual, but others can't. The terms of the tenure in a lease are partly in accordance with general principles of land law and partly in accordance with the lease covenants, which are created by contract, but annexed to the property rights of landlord and tenant. And if we want to change the nature of that tenurial relationship by statute, we can, as we frequently did in the 20th century, and it sounds like we may be doing again quite soon. But we don't need to treat leases as anything other than estates in land in order to do so. So as you can probably tell, this is a fairly ambitious overview of what I'm trying to achieve over the next probably couple of years. The tip of the iceberg. The longer term project is to try and explain the history of the lease as an estate in land in English law, to try and untangle these oscillations between personal and real property that it's gone through over time. And the end goal in doing so is extremely practical, because I think the law of leases as it currently stands lacks coherence, partly due to a lack of historical awareness and partly due to too much contract law being applied to relationships concerning land. So I hope having a look at how we ended up here and the land law of centuries past will help us to improve the law of leases as we go forward. That's me done. Do you want to take the slides down? I don't want to touch it in case I break it, given what the IT guy said.
Thank you so much, Dr. Eldridge. That was a wonderful and entertaining presentation. We'll now take some questions from those attending in person and online. If those online wouldn't mind either raising their virtual hand or typing question in the chat, that would be appreciated.
It's unfair to make Neil ask a question because he's already asked a lot of them.
Could I ask two things? One thing was, did we really have to wait for 100 years to get registration of title, given the 1925 Act?
Yeah, so that was a...
I persuade my students to believe that there was registered land before 2002.
Yeah, that was me being carelessly oversimple. The 2002 Act, I think, marks a watershed in the sense that we now think of most land as registered. I'm not sure what the latest figures are. I think 11% is not registered, or maybe even 9% is not registered now. So yeah, you're right. Of course, there's a Land Registration Act in 1925. I think land registration was introduced in London about 50 years before that as well. But it's the sort of the fact that most land is registered, I suppose, after 2002 or not long after.
And the other thing was, and there may be nothing in this at all, but it occurred to me that another case in which there is both some sort of proprietary interest in the land and an ongoing contractual relationship is a mortgage.
Mm-hmm.
Does that shed any light on leases or leases and mortgages?
Mortgages.
Completely different.
Well,
and mortgages would potentially involve lease.
Yeah, so mortgages in the 1925 Act is a horror story. Because the first phase of reforms, so the stuff that's introduced in sort of the third quarter of the 19th century, the first sort of legislative proposals, they propose that you will use a long lease for a mortgage, and the barristers don't like it. And it takes about 50 years for them to sort of calm down and accept that that's a way of doing it. But again, I've looked at the discussions about mortgages, and they're very, very heated discussions. And people obviously have huge vested interests in mortgages not changing as barristers because they're worried they're going to lose a lot of business. But they don't talk about what a lease is in the context of those conversations. They just sort of take it as a given that it's a tool that we can use for this without any changes to the tool itself, which again, I think is interesting, but it's interesting because it's a negative again. I've looked through a lot of select committee reports and Hansard and that sort of thing. I've got quite a lot of solicitors' journals to still work through. And the thing that consistently surprises me is how little they talk about leases in the context of all of this.
You mentioned a lack of coherence with the contemporary leases and the potential interference in contract. How would you relate that in medieval times with the common law having a say on leases and then equity trying to interfere when need be? I don't know if you gave that. But.
So this is the big chunk that I haven't even started yet, because I've been focusing on the paper for Oslo as opposed to the book, which I'm supposed to have not started yet. I think, so Neil has a really nice paper from the early 90s which talks about the use of long leases as a tax evasion tool, and the relationship between using leases as a kind of form of evasion and then them becoming widely accepted and how that kind of process happens. I think that's a fair summary. Sorry. And so I think that there's something very interesting there going on in terms of what leases are being used for and what the acceptable boundaries of the concept are, which it does involve the relationship between the common law and equity. But in terms of the actual enforcement of particular leases, there's a lot of case law work that I just haven't done yet.
One case you might find interesting, which kind of like brings mortgages and leases the same argument with common law equity, is Iran Bank versus Ministry of Defense. This is a Supreme Court case 3 years ago, somewhat 3 years ago. You might find it really interesting because it touches on these things, albeit it's more about the tax evasion case. But
yeah.
They delve into all these details.
I think I vaguely remember it, but I don't think I've read it in detail.
Project Blue, sorry, versus Iran Bank or the Ministry of Defense. Yeah.
Thank you.
Any questions from any of our online attendees?
Don't say something about Roman law.
No, not Roman law. Very modern. I'm just thinking, to what extent thinking about the intellectual history side of it is the sort of contractualisation of property law a very recent phenomenon. I think it's also something we have in the academic literature on trusts in the last few decades. Can we just rethink it all in contractual terms and sort of eschew traditional property ideas?
But I think I'm not as familiar with the trust. I'm aware of it, but I'm not sort of in there. Is it not all being driven by the same kind of idea that things need to be commercial?
Commercial freedom of what the parties want or to dominate at all, is it?
So I think there's these phases as well where different areas of law are engaged. Because if you think about Mansfield and the Lieberman book, The Province of Legislation, really, really good. That's a commercialization process that happens with certain areas of law and not others. And then the next wave of reforms, then they're focusing on commercializing other areas. So it seems like ever since the British Empire first developed, you have these waves of commercialization affecting different areas of law. And I wonder if that's the kind of overall pattern. Potentially one that gets reversed from time to time as well, because if you think about sort of the early 20th century, you have sort of socialism. So there's a nice sort of, it's not linear. And I think that's always very important when we're talking about legal change over a long spread.
I was thinking more just on Bruton, where Hoffman says it's just statutory interpretation, right? It's the reason purpose of landlord tenant act rather than anything else. And whether it's tapping into a very recent attitude towards property that we can just think in terms of contract.
Yeah, and I mean, again, if we're thinking about the attitude in 1925, they were saying family settlements, the way that we've done this since the medieval period, we're not doing it that way anymore. The First World War, all of the heirs go off and get killed anyway. There's fewer heirs to have. And there's this very strong sense that actually tying up land in family settlements, that dynastic ambition, is not what property and land is all about now. And indeed, there are other tools for using it, including trusts and corporations and things like that. So I don't know that that says anything about Bruton. I just hate Bruton. I can't reconcile myself with Bruton. I understand why they reached the conclusion they did, but it's like, so Mark Wonnacott has several lovely books from the perspective of a practitioner. And one of the things he says is, sympathetic litigants make bad law. And I think that's the story there, and that's the story in Beresford and Mexfield as well. Excellent stories, really fun to teach, but bad cases.
Thank you for that. So you mentioned that ideas of simplification and rationalization were kind of the key themes of 19th century land law reform. And then you also mentioned that it was in this context that ideas of tenure didn't really feature in the 1955 legislation. But then you're also advocating that ideas of tenure should also be taken seriously today. And I was wondering if you had any thoughts about whether the intellectual climate has changed from this late 19th century position to today.
Yeah, it's an interesting question. So I think one thing is purely, in a very practical sense, they did not in fact abolish tenure, right? So the fact that that has not happened means that if we want that to be true, if we want tenure not to have a role to play, you will actually need to actively abolish it by an act of parliament. And you theoretically could do that. You'd make a horrible mess of quite a lot of things. Probably not a parliament at the moment that I'd trust to do that well. But you could do it. So one of my points is just because we don't want to engage with this law doesn't mean it's not still sitting there. Another point that I think is worth making is that it can be useful. So I mentioned briefly the common hold, the reforms in 2002 that they attempted to bring in common hold. Again, last time I checked, I think there's something like 38 properties registered in the entirety of England and Wales that use common hold. That's not worked. And leasehold in terms of blocks and flats, it's not working right now as it is. And it's pretty obvious when dozens of people die that that's not working. So one of the things that I'm saying in this project is, well, okay, so we've got this medieval law still on the books. We've got stuff they didn't abolish in 1925 that we've not thought about a huge amount, or we've not been very conceptually clear about since then. Is any of that useful? Could any of it help us solve our current problems or shed light on them or help us to understand things better? So in terms of intellectual climate, what I'm advocating is historical jurisprudence, understanding the law through the lens of the past when you're looking to the future. That's kind of my jam. But I think in this context, that's something we're not doing at the moment, but I'd like to see more of. Does that answer your question?
Thank you.
Don't think anyone's got their hand up.
Okay, well, we might wrap it up there. Please do join us at the Granta, and please join me once again in thanking Dr. Eldridge.
Thank you. I should say as well, Rosalind mentioned the book, the monograph of my DPhil is nothing to do with any of this except that it's land law. It's coming out next month, and I have a discount code if anybody wants it for pre-ordering.